Good morning all. I thank you for the invitation as well as the opportunity to address you this morning. I thought about what it was that would be of most interest to students today. And each term we admit a number of young professionals either to practice as attorneys or advocates, and at the end of the proceedings, after everyone has had an opportunity to receive the orders, they are admitting them to the legal field, we proceed with a word of welcome as well as an invitation for them to decide how we're going to proceed forward. Now, what strikes me as interesting is, as legal practitioners, we form 1% of most countries. You are the top tier, and what I invite students to do at that stage is to recognize that as against the rest of the population, you have a body of knowledge before you that you can use to make a change. So it doesn't help to sit and lament about what it is that you are not happy about, but to recognize that that body of knowledge that you have can realize change in the world around you. The first time I had the opportunity to do that was as a public defender. Most of our universities have a law clinic attached to it, and that's the first opportunity that you have to start consulting with potential clients, but also to recognize what your knowledge means to people who are vulnerable, who do not have the same agency that you may have as a practitioner, and how your knowledge of the law can make a difference in their lives. Whether it is related to an unfair employment, unfair dismissal aspect, or whether it is related to an issue of abuse. At the time that I entered the legal profession, we had just promulgated the Domestic Violence Act. So working at a women's support center was important because women felt so vulnerable amidst the rest of the population, and the prevalence of abuse was high. The act that was promulgated at that stage afforded people in domestic partnerships to approach the court for an interim protection order. So where the exchange was verbal, you would just receive notice of the court date, but where it was actual physical violence, the court can order an interim protection order. And the first thing that you'd be concerned about is, but how is an order granted in the absence of one of the parties? The protection that is written into the legislation is that the respondent can anticipate the order on 24 hours notice to the applicant. So it safeguards the rights of the respondent as against the right of the applicant who seeks protection. On the return date or on the anticipated date, either of the parties can place evidence before the court, either to support each of their versions, whereafter a court will make a determination. So, given that violence against women is still prevalent around the world, this is the first instance in which you can make a difference. But also there are other areas, either related to housing, evictions, where people may not have the knowledge that you have access to. And it is important that you recognize that you are able to make a change from that level in a small way, but it means something to your client and the person that you've assisted, given by comparison your wealth of knowledge. Now, in order to ensure that for us, we have our population comprising of 51% of women our constitution requires that that representativity filters through in different positions, whether it is in academia, whether it is in the judiciary, or places of employment. We also have the Employment Equity Act. So I'd like to share, because I think it is a point of interest, how our appointment process compares to the appointment process that you have here. But in order for us as judges to ensure that there is a connection between your theoretical training and practice in court, it's important that you have access to those spaces. And when you graduate as law students and go into a court, it's intimidating. You don't know how your conduct is going to be perceived. There are particular ways in which you address the court. And if you don't do that, the one thing that comes up often is that a practitioner, an advocate or an attorney appears in court but hasn't introduced themselves to the court. So the response would be from the presiding officers that, I do not recognize you. And as you're standing there and wondering, how do you start with your submissions? You cannot start with your submissions if the court has not recognized you. So those little bits of etiquette and information needs to be relayed to you. And to see it in practice, it helps that you are able to attend court. As a founding member of the South African Association of Women Judges, I've served in different roles. At the present moment, I'm Vice President of Programs. And one of our flagship programs is the mentorship program, where throughout the provinces, we have 9 provinces, we have a relationship with the academic institutions. An invitation goes out to the law faculties to publish to the students, and students can then apply to be a part of that mentorship program. For the duration of that period that the program runs, from approximately February to November, December of that year, students are exposed to a number of webinars where you address either the issue of artificial intelligence in law. I don't know what your experience has been in India, but for us, when a practitioner addresses you and you've read the papers beforehand, it will be easy to ascertain whether the case that is referred to does in fact exist. And there have been at least 2 instances in South Africa in the past year where reference has been made to case law that does not exist. And it becomes very uncomfortable as a practitioner when the court asks you about this case. And for us, when we have our computers before us, I will ask the practitioner to just hold on whilst I go on to Judiciary or LexisNexis to look for the case so that I'm able to verify and see what particular paragraph they're referring to, and to consider, does that particular paragraph support their submissions on the point of law that they're advancing. And you will know that AI has hallucinations, which means that it starts developing its own cases, recognizing that AI is a construct of human minds. What you need to consider is, who has input that information? What has been put into that information? What has been put into that base? Because that is how as you understand how ChatGPT and the different AI programs work, it searches its base in order to formulate an answer. But by way of example, if the information is just input from a particular group in society and it doesn't relate to all of the possibilities, you're going to have a limited answer, or the response for your quest is going to be a limited amount of information. And if you are solely reliant on that artificial intelligence search engine, you're going to find yourself in a difficult position when you are asked to give the reference to the case that you're citing and how it applies to the particular submission that you're making. So it's important for us to inform students of this possibility, so you don't stand before a court and are embarrassed and awkward because you have cited something that doesn't exist. Other aspects that we will address with students are questions of ethics, aspects of a particular law during different months where we have a focus on youth, or we have a focus on women. Our Women's Month is in August of each year, which is when we have our annual general meeting as the Women Judges Association. There's also invitation from advocates and attorneys to address our students, and that is in the form of a webinar. And that has become relevant for us because whilst you're sitting in Johannesburg, you could be addressing the rest of the country, because our webinars are open to students who are part of the program across the country. So in that way, we seek to bridge the gap between the theoretical knowledge that you assimilate whilst you are in your legal academic career, so that there is a connection between what you learn. For instance, in your first year, you'll be learning about family law. By the time you qualify, that's four years later, when you get to court, you want to know what the position is with regard to how it applies. For instance, in the domestic violence court, in the children's court, where there be care and contact, where one parent can come to the court and ask for an arrangement to be made so that a child has contact with both family members. We have ratified international conventions which protect children's rights. So what has been filtered through and what appears in our Constitution is that in any matter before court, a child's rights and interests are paramount. So the court has to take that into account. Whether it comes before you as a matter in the children's court where care and contact is being inquired about, or where it is a matter of child neglect or removal of a child. It also relates to issues of equality and how you recognize the applicant's rights before you. So this program we are very proud of because it allows for contact and access. I've spoken to your legal practitioners and to your principal, and I think it would be a wonderful opportunity where you are able to access those webinars so that you're exposed to information in a different part of the world. And in terms of your AI experience, so your world becomes bigger. You are able to compare the application of law in one country as opposed to the application of law in your experience in your country. And that will open up avenues for discussion. So I hope that going forward, that will afford you a richer experience in terms of your learning, but also in terms of your practice. Because you remember we have a process of precedent. Whilst we do apply the law in our country, you are able at some point to reference an aspect of the law that is applying perhaps more creatively or constructively in another country, and you can invite the court in your country to consider that aspect. Another point is, I understand that your appointment to the bench is internally through the judiciary. Because of the changes that we've gone through, our Constitution requires that that process follows a particular course where you have to have a certain number of years of experience. You are nominated by any law organization or any person. You submit your application along with 3 of your judgments, which means that you must either have a body of writing or you have acted as a judge for a period which allows you to produce those judgments. The process allows for shortlisting of the applicants, and when you're interviewed not only by judges, but by a commission that is made up of representatives from the judiciary, representatives from academia, because you wanted to be able to interrogate the content of the writing, as well as representatives from the legal profession and members of parliament. So it allows for a wide range of participation from different groupings in society to ensure that the appointments that they make to the judiciary will suit the purpose that the appointment is for. So I invite you to post questions after we all have an opportunity to speak, and we can engage around the issues that have been of interest to you. Thank you for the opportunity to address you this morning.
We will now proceed with a brief interactive session where students may ask questions to our guest.
Good afternoon, ma'am. My name is Sneha Khan. Ma'am, according to you, which social custom still limits the empowerment of women?
I just want to repeat the question so that I'm sure that I understand it. You asked which social customs?
Like social customs which are we follow traditional.
So cultural customs,
Yes.
which promote the interests of women, which empower women. So,
which does not empower women.
okay.
Which breaks the social customs.
So in South Africa, a practice that provides only for, and by way of example, and I was discussing this yesterday, if parties are married in a community of property, where both parties accept the benefits as well as the debts in the partnership, where a spouse, and by way of example, the husband incurs debt which the woman has not been responsible for. If at the end of that marriage, the community of property process is applied, you will find that the woman will be paying for debts that she had not been consulted about or that she had no interest in. And where the marital regime is in community of property, that has been the norm, and women are not necessarily protected in that instance. What it requires is that after the marriage, you bring an application which changes your regime to that of out of community of property, so that your estate is different to your spouse's, and to the extent that you engage in economic activity, you don't mulct your spouse's estate with the burden of paying those debts, and similarly he's not able to burden your estate. That's the one example. The other is by way of cultural practices in terms of inheritance, where it provides specifically for male members of society to inherit, and it doesn't allow for equal access for women. That can be contrary to women's interests, because it doesn't allow for the same kind of economic opportunity and development where land is only devolved to a male part of the family as opposed to female members of the family. That's just, so often it is when cultural applications of the law, they must withstand the constitutional imperatives where you cannot discriminate on the basis of race, gender, or any other aspect in terms of our Bill of Rights. Thank you.
Hello ma'am, my name is Shanaaz Mia, and it was really nice to hear you. You sound very soft and comforting, and at the same time enlightening also. My question is, we are talking about women empowerment, and in the world, women empowerment, the term itself has become very vague these days, and dissected mainly into two parts. On one part, we have women who are scientists. You are a living example in front of us right now. And then there is a crowd which is talking about women empowerment, but at the same time trying to break the fabric of society and the gender roles of women, which is basically that builds a family. So they are also trying to break institutions in the name of women empowerment. How would you like to define women empowerment for us?
So in my view, the empowerment of women must allow for the active participation in all aspects in society. So when you say that there are those groups within society that advocate for empowerment but don't necessarily apply it practically, I think one has to look at the position in each society and examine whether the way it is applied, it allows for maximum participation of women. And it is not necessarily that that participation is limited to one particular area. Your example was breaking down the family. It requires us to re-engage with the construct of the family because that has changed over time. And to the extent that women are able to participate on an economic level, on a spiritual level, and recognizing the contribution that they make to society in terms of the procreative aspect, where women are birthing children and they're required to look after children for a particular period in life in society, because that base, if we do not recognize that time where women are contributing in that manner, it doesn't allow for the growth of society in a whole. And where that is particularly applicable is where in a relationship, a woman's contributions by way of her contributions in maintaining the house does not have economic value. We need to attribute an economic value, because without that, if you removed the contribution that a mother and a wife makes, you're going to incur the cost of a housekeeper, a nanny, a home executive, and it would be interesting to compare the cost thereof versus the contribution that a woman makes, and look at what economic value are you attributing to the woman's contribution. And so it requires us to reflect on a regular basis, what does it mean for us at a particular point in time? And the issue of care for the children, does that at some point become a shared responsibility? And how do we support the care of the children while still allowing for women to participate actively, either by choice, and sometimes it's by way of necessity.
Myself Priya Kadam. My question is, what ethical role should advocate play in women-centric cases?
So I thank you for the question. I understand you to be asking what role women advocates play in women-centric cases. Let me start off by saying that from my position in terms of our Constitution, it is not only women who are responsible for developing the interests of women. And as the Association of Women Judges, we have males
who are members as well. It's because we recognize that men are in a position of power and can assist in developing women's interests. So whilst women have a learned and lived experience of what women's experiences are, I think they play a very effective role. But I think it still remains the responsibility of both genders to ensure that in women-centric matters, that those interests are recognized and realized. But given that we have more women entering the profession, we recognize that there's a crucial role that women play. Thank you.
Good afternoon, ma'am. My name is Ram. You were convinced that expertise in the field of psychology and law would be most needed in the country in future. Is there any connection between law and psychology?
So you'll find that there are writings that suggest that when a jurist is appointed, it is important for them to have an understanding of society. In my experience, I think that my undergraduate degree in the Bachelor of Arts, where I majored in psychology and sociology for a period of time, those are important in informing your understanding of the application of law. Law is not applied in a vacuum, it's applied in society. And so your understanding of sociology and how society works gives you an advantage in terms of being informed of how you would apply the law. So you are better able to address the advantages, the disadvantages, and to understand how society has developed and how you want the law to apply at a particular point in time. Thank you.